In the case of California versus CAvSciraolo, it dealt with the Fourth Amendment and the search and seizure laws of the United States of America. In this case, there was a unanimous caller who called the police station about some marijuana, and these two people's conversation went something like this.
Hello? What is your emergency?
Oh, hello, Mr. Officer Man. How's your evening?
Ma'am, this is an emergency line only. Do you have any emergency?
Oh, yes, I was walking my dog, Mr. Spunkus, today, and I smelled this peculiar aroma around this young Hispanic boy's house. Smelled like the reefer.
You mean marijuana?
Yes, Mr. Officer, I smelled the marijuana. He lives at 420 South Cannabis Avenue.
Okay, what? Thank you, ma'am. We'll look into it.
After getting this unanimous call, the police station rented a helicopter to go investigate this weed, since they had no search warrant. And after doing this, they seen that there was marijuana involved, so they went and took it to court, and CAvSciraolo pled guilty in doing this, but he appealed it because he thought that their judgment was wrong, because they thought that they used false evidence against him. So he appealed to the Supreme Court of the United States. In doing so, the Supreme Court found that it was constitutional that he did these things, because the search through an airplane the marijuana could have been seen in airways by any other person, and they were not in any place that they shouldn't have been. The air was a public airway, and it was all okay. So CAvSciraolo had to go behind bars because he was guilty, and the arrest was constitutional, and that concludes our case on California versus CAvSciraolo. And if you would like to look into the case anymore, here's a few resources that we used. So if you want to learn some more about this interesting case, feel free.